So when we were talking about topics for today's seminar, three bills came to mind that are amending, as Ron said, the Employment Standards Act. And of course, when we chose the topics, an election hadn't been called, so I have these three relevant bills to talk about and some leaves that I'll also talk about as well. Well, when the election was called, the bills died. So here I am talking about these bills. But the good thing is the election has happened now, and I know that the same party is back, so these bills become even more relevant. Although they won't come back necessarily with the same names and titles, we now can take a look at these bills and understand the impetus for the changes or why the government wanted to change the Employment Standard Act language. And so when I go through the bills, I'm not going to talk about them with as much specificity as I might otherwise do, but I really think the concepts behind why the bills were tabled in the first place is particularly relevant today. I'm also going to talk about some leaves under the Employment Standards Act. These leaves will take effect in October, so as employers we need to be prepared to now deal with 10 leaves under the Employment Standards Act as opposed to the 7 we are currently dealing with. So the first bill is Bill 170, and it's referred to as the Employment Standards Amendment Act, Greater Protection for Interns and Vulnerable Workers. So we've seen a change both at a federal and a provincial level in the government's attitude towards unpaid internships. And we saw recently at a provincial level the Ministry of Labour go into 2 prominent magazines, Toronto Life and Walrus, and issue some orders in respect of their intern program. Now, those 2 magazines ultimately shut down the unpaid internships that they were offering because compliance with these orders by the ministry was just too significant. So this bill sought to amend the definition of employee under the Employment Standards Act. So to be governed by the Employment Standards Act, you need to be in an employee and employer relationship. What was happening is that these unpaid intern individuals were not falling within the definition of employee. So there is a definition of employee that includes individuals in a training relationship with the employer, but then the section went on, or a separate section listed several factors that if the employer could establish those factors existed, the individual would not in fact be an employee, and thus the rights and entitlements under the Employment Standards Act didn't apply. So employers were essentially free to treat these unpaid internships in any manner they saw fit. Again, so the bill then changed the definition of employee to remove those criteria. So now an employee would be an individual simply in a training relationship with the employer. Further, the definition of employee would have been extended to include individuals from a co-op, from a high school program. Use high school co-op programs, various sections of the Act are now going to apply to them or would have applied to them. Additionally, students coming from a college or a university would have been captured by the employee definition who would not otherwise have been prior to the amendments. So not all the areas of the Act or the Employment Standards Act would have applied to these unpaid interns by the proposed amendments, but record keeping, so there would have been some new obligations on you as employers in respect of record keeping, hours of work, so again, the overtime issues, eating periods, you'd have to make sure that these employees had sufficient breaks. The leaves, so pregnancy leave, paternity leave, all of those leaves would be something that these individuals would be entitled to, and also vacation. So there would be a vacation time entitlement as well under the amendments. Additionally, although the Act, even in its title, refers to unpaid internships and amending the Employment Standards Act to deal with these unpaid internships, it also sort of sneaks in another little interesting change. And this was about how complaints can be filed with the ministry. So under the current Act, or under the ESA currently, complaints have to be filed by the individual. So the amendments would allow a third-party complaint or an anonymous complaint to be made. So you can imagine now that employers, if that piece is passed, are going to be subject to much more scrutiny by the ministry in terms of whether or not they're meeting the minimum standards under the Employment Standards Act. If individuals can simply call in and say, I don't think this particular employer is calculating vacation pay properly, that could trigger an inspection or an investigation and ultimately enforcement being issued under the Employment Standards Act. The second bill was Bill 146, and this was Stronger Workplaces for a Stronger Economy. And this really empowered employment standards officers. And this links, I think, nicely to the last piece around the ability to file a complaint and removing the requirement that an individual has to file that complaint. But under this proposed bill, the $10,000 cap as an award of wages that an employment standards officer could previously issue was removed. So you can imagine that much larger claims would then go before an employment standards officer than ever before. Additionally, the employment standards officer is currently limited to an award of 6 months. So wages that were earned in the last 6 months that are deemed owing could be awarded by the employment standards officer. The proposed amendments gave a 2-year limitation. So that 2-year limitation is reflective of the Limitations Act. So you can see now a potential, if this legislation or some similar form passes, a shift from the court system and more into having some of these employment claims adjudicated before a tribunal in the employment, before an employment standards officer. Another interesting change, proposed change, was the requirement of a self-audit. So basically, an employment standard officer could say to an employer, you, employer X, are required to audit yourself in respect of Y. So I want you to look back, for example, in your records over the last 2 years and provide me information in respect of the vacation pay you have provided your employees. And then you're going to report to me your findings, and you're going to do it in a specific format in a specific way. And then I'm going to decide whether I need to investigate, inspect your workplace, or if I'm going to enforce, issue any enforcement orders against you. So not only would the shift be in totality from an individual bringing forward a complaint to potentially third-party complaints, anonymous complaints, but now you'd almost be required to tell on yourself if you got this written notice of self-audit. The third bill is Bill 159, and this is amendments to the Employment Standards Act to address temporary help agencies. And the tone of this bill suggests that the government is not very happy with how temporary agencies have been run or how employers are using temporary help. So in this particular bill, a temporary help agency would have been required to get a license, and that license could only last for a year, and then they would be required to renew that license. So that would be a pretty frequent renewal by the agency. Further, there was some restrictions on the amount the agency could take per hour from the money they received from the third-party employer. So the agency was required to pay to the employee 80% of whatever hourly rate they received from the third-party employer. There was also some restrictions placed on the third-party employer. If you had more than 10 employees, you could only use agency workers for 25% of the hours worked by your employees in a work week. So you'd be required to keep additional records. I have X amount of employees, they worked X amount of hours, 25% of this is Y, and that's the maximum amount of agency help you could have for that week period. There was also some shift in liability. So for employers, if you've paid the temporary help agency for the services received and that temporary help agency does not pay the individual, you could be liable for some or all of those wages owing even though you've already provided them. Obviously, the first recourse would be against the temporary help agency, but you as an employer could ultimately be liable, which could effectively double your cost of using these agency workers. There's also some shifting of liability under the Workplace Safety and Insurance Act. So if you're using temporary help agency workers and they're injured on your workplace, that would become your responsibility as a third-party employer. All of their wages earned would be attributed to you, and there would be some, again, some shifting of liability. So what we're seeing from the three proposed bills, and one of them was proposed by the Minister of Labour himself, who was re-elected last night, is some further government oversight into the workplace and further government regulation and enforcement of the minimum standards set out in the Employment Standards Act. And although it seems at first blush a simple legislation, a piece of legislation, it is actually rather complicated. So employers are really going to be looked at to ensure that they're compliant with the obligations under that piece of legislation. Now, changes to the Employment Standards Act will take effect. So this is not a bill. This was a bill initially, obviously, but was ultimately received royal assent. And on October 29, 2004, 3 more leaves are coming into play under the Employment Standards Act. So these are in addition to the leaves that already exist. So they're not trumping one another. The employee can use those leaves in a row. The first one is the family caregiver leave. So this is a leave that will entitle an employee to an 8-week unpaid leave if a qualified health practitioner certifies that one of identified individuals has a serious medical condition. So qualified health practitioner is defined, includes a physician, a psychologist, or a registered nurse. The individuals that are listed are the employee's spouse, parent, child, grandparent, spouse of a child, employee's sister or brother, a relative that is dependent on their care, or an individual who's prescribed as a family member for the purposes of the leave. Serious medical condition isn't defined. All they say is it can be chronic or it can be something that occurs in episodes. It's an unpaid leave of absence, as I said, to a maximum of 8 weeks. So what you might see as employers is this taken in conjunction with the family medical leave. So initially the individual goes off for the 8 unpaid leave days for the family caregiver leave. If the individual who they're caring for conditions worsens, and worsens, then they may in fact be entitled to the family medical leave. So instead of looking at 8 weeks under the family medical leave, or you're looking at 8 weeks under the family caregiver leave, you're looking at an extended period of time off. And there's no minimum period that the employee has to be working for you in order to be entitled to this leave. And again, it's a job-protected leave, so they're entitled to all the protections that they would have been, say, if they had a pregnancy leave or a parental leave. And I should also say that it's 8 weeks per calendar year per person on that list. So if they've taken 8 weeks in respect of their mother, for example, they are entitled to another 8 weeks of unpaid leave in respect of another family member, say, for example, their father on that list. The next one is the critically ill child care leave, and this is a leave that, again, without pay, that allows the employee to provide care or support to a critically ill child if a qualified health practitioner issues a certificate that states that the child is critically ill and that the child requires care and support of that particular parent, and the period of time that that child requires the support. Child is an individual is defined as stepchild, biological child, foster child, or child who is under the legal guardianship, and an individual who is under the age of 18. To be critically ill, the child must have a baseline state of health that is significantly changed and whose life is at risk as a result of an illness or injury. So this is a 37-week unpaid leave. However, the employee doesn't de facto get 37 weeks. They would get the amount of time off as required by the certificate from the qualified health practitioner. If in certain situations there's an accident where the employee has multiple children who are injured, the total leave in this case is 37 weeks. So it's not, you don't get 37 weeks per child. And there is a minimum requirement in that the employee has to be working for the employer for 6 consecutive months in order to be entitled to this leave. The employee does have to inform you in writing that they're taking the leave, either before the leave or as soon as possible thereafter, and you actually have to come up with a written plan as to what weeks the employee is going to take the leave. If the initial certificate says the week is going to be for 10 weeks, for example, they can provide subsequent certificates up to 37 weeks. The third leave is I find a bit odd, and I would like to know what drove or why the government felt they needed to include this in the Employment Standards Act. But this is a leave for crime-related child death or disappearance. So if an employee has a child who dies as a result of a crime, that employee is entitled to 104 weeks of unpaid leave. If the child disappears and it's suspected that the disappearance was linked to crime, that employee would get 52 weeks of unpaid leave. If the child disappears and you start the 52 weeks and they're subsequently found to have died as a consequence of the disappearance, as a consequence of the crime, that employee will then be entitled to the 104 weeks. If the employee is charged with the crime relating to the disappearance or the death, they don't get the leave. Surprise, surprise. But if the child is engaged in the crime, you don't get the leave either. So even if your employee's child dies during the commission of a crime, you do not get the leave. The employee would not get the leave. So it's a bit confusing and just strange to me. Again, you have to be working for 6 months, or the employee has to be working for 6 months to be entitled to the leave. The employee has to advise you in writing of the request for leave and again have a written plan. The leave then goes on to speak about what happens if the employee's child disappears and they are found. Well, the employee has to return to work under the language within 14 days of that child being brought back to them. Again, another oddity. Again, if the child dies during the leave, the employee does not have to return till the 104 weeks are up. So although I talked about 3 bills that, again, are not necessarily going to be around, I think with the new government, those bills are going to be resurrected under potentially new names. We'll obviously keep you advised. I think we know that hot topics for the government are unpaid internship, temporary help agencies, and really beefing up the enforcement rights of employment standards officers and the ministry under the Employment Standards Act. We also need to be cognizant of these 3 leaves, 2 of which may come up more frequently than the other, hopefully. Thank you.